So, what exactly makes a deadline in a contract a real deal breaker? We're going to find out by diving into a 1987 case, Lombard versus Butterworth, where just a few simple words turned into an absolute game ender. It's a question that pops up constantly. If you're a day late on a payment, is that just a small slip up, or does it give the other person the right to just walk away from the whole agreement? Well, this case gives us a super clear answer. All right, let's set the stage here. The whole story kicks off with what should have been a really simple everyday transaction, leasing a personal computer. So on one side, you've got Lombard North Central, they're the finance company, and on the other side is Mr. Butterworth, the customer. Lombard agrees to lease him a computer, and he agrees to make regular payments for it. Seems straightforward enough, right?
Yeah, but as you can probably guess, it didn't stay that simple for very long. The entire fight, the whole thing, boils down to just one specific, very powerful clause that was tucked away in the fine print.
And here we have it. I want you to pay really close attention to those 5 words. It is of the essence. This phrase is the absolute heart of this entire dispute. This isn't some friendly suggestion, okay? It's a declaration that paying on time is completely fundamental to the whole deal. So how did Mr. Butterworth do with those payments? Not so great. He was late, consistently, month after month after month. We're not talking about a one-off mistake. This was a clear pattern of just not hitting those deadlines. Okay, so after 5 late payments in a row, Lombard finally said, "That's it, we're done." They ended the contract, they came and took the computer back, and then they sued Mr. Butterworth for all the money he still owed, plus damages. And that's when things really kicked into high gear and headed to court. Now for the court, this whole case came down to one absolutely fundamental idea in contract law, the difference between something called a condition and a warranty. And trust me, getting this right is everything. Okay, so think about it like this. A condition is like the engine in a car you just bought. If the car shows up and there's no engine, well, the entire point of the contract is totally defeated. You have every right to say, nope, take it back, and end the deal. It's that fundamental. All right, now a warranty, that's more like finding a scratch on the paint of that brand new car. It's not great, it's a flaw, and you're definitely entitled to some money to get it fixed. But you can't just hand back the keys and demand a new car, right? The main purpose of the deal, getting a car that drives, is still intact. And this is where it all comes together. The difference is huge. If someone breaches a condition, you get the ultimate power. You can terminate the entire contract and sue them for damages. But if they only breach a warranty, you can only sue for damages. The contract has to keep going. So the big question for the court was, what was this payment clause? A condition or a warranty? So keeping all that in mind, the judge had to figure out if Mr. Butterworth's late payments were that missing engine or just a scratch on the paint. And the verdict? Well, it was a slam dunk. The court sided completely with Lombard, the finance company. Mr. Butterworth lost the case. So why did they rule that way? Well, here's the logic. The judges basically said, look, normally a payment date might be considered a less serious term, a warranty. But because the contract specifically said that timely payment was of the essence, the two parties basically wrote their own rulebook. They decided ahead of time that any lateness was a deal breaker, period. Look, this isn't just some boring old case from the law books. What it established has a massive impact on any agreement you or I might sign today. This case, Lombard versus Butterworth, is literally the reason why phrases like time is of the essence carry so much weight in modern contracts. They're not just fancy legal words. The case confirmed that, hey, if you want to make a deadline a non-negotiable deal breaker, you can. You just have to say so in the contract. So what's the big takeaway for you in all this? A few things. First, and this is the big one, always read the fine print. If you see that phrase, time is of the essence, you need to know that those deadlines are rock solid. And before you sign anything, get really clear in your own head what a condition is versus a warranty. For you, what are your absolute deal breakers versus the things that are just nice to have? And that really leaves us with one last question for you to think about. The next time you're about to sign something, a lease, a job offer, whatever, take a second and ask yourself, what's the one thing in here that's so important that if it goes wrong, the whole deal is off for me? Because figuring that out up front, well, that could save you a world of headaches later on.